Thank you, Mr. Chairman.
Do that. We're going to call this meeting to order. The first file for our consideration is Senate File 53, Trademarks and Trade Names, Administrative Cancellation. Appearing with us today is Mr. Secretary of State and his staff, and we're glad to have you, sir. And if you want to start this one, that'd be great.
Well, thank you, Mr. Chairman, and want to introduce our staff at the table today. I know we have a new committee, and I just want to say I'm really looking forward to working with you all. I'm Chuck Gray, the Wyoming Secretary of State. To my left is Joe Rubino, our General Counsel, our Policy Director. He does so many other things as well. And to my right is Colin Crossman, our Business Director. And we're very excited about these bills. This is our interim committee request to combat business fraud in Wyoming. And I want to be very clear, and I do think it is a change from my predecessors, that we take fraud. We are not just saying that maybe there's nothing to see here. We acknowledge that we need to address these issues. And, you can see it not only in the wording from what I've said when there have been issues that have been raised, but also in the action. And that's why we were very excited to request this interim topic, the Joint Corporations Committee, and excited to work with you, not only with the interim topic, but also in the working group that was created. Now, Senate File 53, which pertains to our office's interim request for an examination and exploration of ways that our office can better serve the public when instances of fraud, misstatements, or misuse of trade names or trademarks occur, without forcing those individuals to automatically resort to judicial intervention. And that's really what we're trying to effectuate here. As we outlined during the Corporations Committee meetings in April and August, the grounds for dissolution of trade names and trademarks are far more limited than those of other business entities registered with our office, such as corporations and limited liability companies. Unlike corporations or LLCs, holders of trade names and trademarks, with limited exceptions, commonly have to resort to costly and time-consuming litigation in instances where they are victims of false or fraudulent filings interfering with their holdings. Senate File 53, as written, would allow for administrative dissolution in appropriate instances by our office so that holders of trade names and trademarks do not have to expend resources on the judicial process, while still allowing for judicial review of those administrative dissolution. I'm going to go ahead and yield to Mr. Crossman on the practical and technical implementation of this bill, as it will require limited system changes for our office to accommodate a new amendment type for administrative cancellation for trade names and trademarks, which we do have in our standard budget to cover.
Thank you, Mr. Secretary. Mr. Crossman, how are you? Good to see you.
Good morning. Thank you, Mr. Chairman. This is basically a change that aligns these two types of documents with most entities, so that if we have evidence that there is a false or fraudulent filing, we can take steps to administratively cancel them rather than requiring everyone to resort to the court system when these things are pretty clear, but keeping in place the protections so that if we're wrong, the court system is still open, or if we choose not to, if we believe that there's not enough information, the party can still take it to the court. So it has both levels of protection there. And as the Secretary said, there would be a small change to the system that because we have to create a new entity, a new filing type for the amendment that would be the administrative cancellation. That is a relatively small change. I don't know if we have a fiscal note even on that, because I think it can be done inside of our normal update procedures.
That sounds great. And before you get started, maybe, could we talk about what the kind of the facts might be of a circumstance where this happens for the new committee? I mean, it's
Absolutely.
where someone's basically pretending to be your company in a way. So maybe you could have an example without, maybe not using specifics, but please, if you could.
Absolutely. So I'll be very careful not to, I'll try not to put out the specific example in detail, but there have been, there was at least one situation where an entity was using a name for decades. And there was a internal struggle between some of the members of this organization. One of them was expelled from the organization and turned around and filed a trade name against this, or well, on the name of this organization. The organization hadn't filed a trade name, and in the process of filing for a trade name, you have to allege that you have been using the trade name in commerce and all of these various things, and that you have the right to it. Well, this person had been expelled, did not have the right to it. I was presented with the information showing that this person had been expelled, yet they filed the trade name after the date of the expulsion, and found that it's pretty clear that this person did not have the right to do this. However, because of the way the statute has been written, if this were an LLC, it would be trivial for me to take care of it. But because it was a trade name, it would have required court intervention and all that. Now they, after some cajoling, they did end up resolving it, but it took probably about a year. Nobody in that case that just concluded a couple of weeks ago. We did not require everybody to go to court. They did not go to court, but had they not backed down, it would have been a pretty expensive court case probably. So that situation fortunately resolved. But had I been able to just cancel the mark or cancel the trade name at the beginning, it would have been a couple of weeks instead of 13 months.
That's a good one. Thank you. Please go ahead.
Mr. Chairman, I just want to
Mr. Secretary.
reiterate, thank you. I just want to reiterate that this aligns our dissolution authority for trade names and trademarks with our dissolution authority on other corporate or other filings. And so, and that's something it's a new committee, if 60 seconds of indulgence. That's one other change we've made is we have been dissolving entities where there are clearly fraudulent filings with our office. Now that statutory authority has been with our office for some time. However, we have no record of it really ever being used until our administration. And so we're up to, it's over, I think 60 now. We just had one the other day that came through, and we have a procedure now for that dissolution. And this just aligns the dissolution authority for trade names and trademarks for other entity types filed with our office. I do want to emphasize that.
Thank you, sir. Should we go back to Mr. Crossman? Thank you.
Well, Mr. Chairman, I think that was the extent of everything I had for this. This is straightforward, as the Secretary said, aligning it with the authority we have in other areas. The new entry type in the system is a trivial matter, and as to staff time and things like that, while we do have, as the Secretary referenced, we've had about 60 administrative dissolutions for fraud of regular entities. These would not be much addition to that, and it's fortunately we don't have them every day.
That sounds fabulous, but is there a chance you could take us through the bill, page by page? Or maybe just paragraph by paragraph?
Mr. Rubino, could you?
Or either one of you, I'm sorry. Mr. Rubino.
Yeah,
you'll do
Mr.
that?
Chairman,
Thank you.
Joe Rubino, happy to do that. Happy to walk through the bill. Let me
Sure,
just pull it
thank
out of
you.
my binder so that I'm not shuffling through. Section 1, beginning on page 1, line 9. This is really creating a new section, and as the Secretary and Mr. Crossman already mentioned, this really does mirror the administrative dissolution process that we see for other business entity types filed with our office, notably LLCs, nonprofit, profit corporations. It enables in section 40-1-108, it enables a new type of cancellation beyond cancellation through the judicial process. Romanet 6 there, beginning on page 2, line 4. Any registration, if the Secretary finds that cancellation, this is where it mirrors the language from the LLC statutes and the corporate statutes that we talked about this summer, or during the interim, is in the public interest and that the applicant or registrant, that's unique to trade names, trademarks, has provided fraudulent information or has failed to correct false information upon request of the Secretary on any filing under this act, subject to the following. If the Secretary, capital A, if the Secretary determines that the grounds for cancellation under this paragraph exist, the Secretary shall send written notice and examination. This is a little bit about what we talked about this summer, again, mirroring LLCs, other business entity types. We give 60 days notice going into capital B, in which the registrant can file a response with our office. There may be a misunderstanding, there may be just a whoops on their end, a clerical error, switching of numbers, something like that. But they have 60 days to provide written notice that is satisfactory with our office. If they do provide satisfactory evidence that there was some mistake or a clerical error, or perhaps that party is in the right and the individual, the applicant or the registrant submitted an affidavit that turns out to be incorrect, then to our satisfaction, that can resolve that right then, and then we do not cancel it. I see, if you want to
Mr.
add
Crossman.
something.
Yeah, thank you, Mr. Chairman. I wanted to, of those approximately 60 in the entity context that we have processed for the fraudulent filings, about 5 or 6 have provided us with sufficient information for us to rescind the fraudulent order, because they had provided us with evidence that actually everything was fine or it was a misunderstanding.
And that uses the same 60 days?
Well, so it's the same 60-day period, yes.
Yeah, great. Back to you, Mr. Rubino.
Thank you, Mr. Chairman. Down at the bottom of page 2, capital C, this discusses if the registrant's response isn't satisfactory, it doesn't demonstrate that the dissolution or the cancellation should occur, then the Secretary shall cancel the registration and send written cancellation notice to the address of record via certified mail. Page 3, beginning on line 7, this provides for judicial review. So again, one of the things that we talked about this summer is, this still provides after the exhaustion of your administrative remedies, which is the sort of the cure period, for lack of a better word, where they have 60 days, they can still appeal this to a court of competent jurisdiction. Down at the bottom of page 3, this is the same, this is for, let's see. This is for trade names, and it essentially mirrors that of trademarks, providing for the same 60-day notice after we've received satisfactory information. One thing that I believe we talked at length about this summer was our process of not merely providing an email or a letter or anything. We require that they provide an affidavit sworn under oath, and that is a filing with our office, so that they take this seriously, right? A false filing with our office, the other way, is also a felony under Wyoming law. And so by requiring that they do this, I think it elevates this process. It's not just willy-nilly cancellations, not just frivolous filings for these sorts of things. Everybody has to be on record. These all become public record. And, we've released these. So everybody's on the hook for these types of filings. So anyway, that goes through the same 60-day process down at the bottom of page 4, capital C, again mirroring that language, and then capital D, the right to appeal to a court. Page 6, top of page 6, section 2, effective July 1st, 2025. While this will require, again, a small administrative change within our existing filing software system, WyoSuite, we do anticipate that this can be done in this period. So
Fabulous. Let's if we could take just a tiny time out. Maybe it's obvious to everybody, but would one of you explain the difference between trade names and trademarks and how they might be used just for the committee or people online? Mr. Crossman.
Yeah, thank you, Mr. Chairman. So in many states, when you have the business entity name, and the business can be doing business under a different name, I'll call it doing business as or DBA. In Wyoming, we do not use that term. That term here is trade name. So that trade name here, you can hear it in your head as just a DBA. So it's less than a trademark. It is just effectively a second name for your business. In a lot of cases, let's say you have an LLC, in the entity name, the term LLC, that phrase or the wholly spelled out limited liability company must be part of your name. When you adopt a trade name, that component does not have to be there. So many businesses will have their business name, say Bob LLC, and then they will have a trade name, just Bob. So they can use that trade name as a secondary name to clean up or make their name a little bit easier. Or if they have multiple lines of business, you can have one LLC with a set of trade names that go along with that business. They are less than a trademark. A trademark is a designation of origin of goods, and it is it's a higher bar. There's a entity names and trade names. The zone that you have protected is very small. It's called distinguishable. So if a name is distinguishable from another name, then it can be used in conjunction or in opposition. So if you have, say, LLC 1 and LLC 2, those are distinguishable from each other. Trademarks create a broader zone of exclusion, and that is you have indistinguishable, but you also have this area of descriptivity, or sorry, I'm getting the term wrong here. It's if it is I'm a trademark lawyer. I should have this off the top of my head, but it's
It's okay.
It's basically
confusing for
it's
everybody.
just a broader zone, so that if something is confusingly similar.
Yes.
And so if you have if you have two things that are similar enough that people would be confused, the trademark will block that second name.
And does a trademark, I think a lot of people think it's a symbol usually. It's not necessarily language, but it could be language.
It could be
right?
language. It could be symbols. It could be the look and feel. It could be colors. It could be, for instance, in the federal context, UPS has a trademark over brown for shipping, the color. So, and it's a very specific color. Trademarks are actually a lot of people. You interact with them daily. The federal context, the state context. So people have a sort of gut instinct as to what they are, but these very specific legal aspect of it is a mark, either verbal, written, it can be sound, visual, that distinguishes your product, your service, your goods from those other goods that are in the same market channel out there. So we have pop, at a cola pop, you have Pepsi and Coke. They are trademarks of relatively similar goods. Now, obviously, they taste different, but you have designations of origin. So if you see a trademark on something, you know, or at least you're supposed to be able to know, this comes from this producer and only this producer. Similar to how, for instance, in the agricultural context, a brand, in fact, the concept of branding came from that.
Perfect. Thank you very much. Let's open it up to the committee, and Senator Boner, you want to start?
Thank you, Mr. Chairman. My question is about, once this goes to a district court, that last sentence saying it may summarily order the secretary to reinstate canceled registrations. I'm just wondering, how does that change that legal proceeding? Is that not currently an option with our judicial system, or how does that language change how that may work if things do, and when things go to court?
Who wants to handle that?
Mr. Chairman,
Mr.
Senator
Rubino.
Boner, I think I understand exactly what you're saying. Right now, as it stands, we do not, for trademarks and trade names, have administrative dissolution authority. So we do have for trade names and trademarks. We do have it for other entity types. And what we have in a variety of circumstances, one that is the most common, that doesn't occur in this context, but say when you fail to file your annual report and pay your annual report fees for 2 years, you cannot be reinstated administratively by our office for an LLC or a corporation. The entity is dead. Unless you seek a court-ordered reinstatement, in which case what we've set up through the Attorney General's office, when we have those, they're very quick turnaround, and someone files, they lay it all out. Whatever the factual circumstances might be. I let my entity lapse for 2 years, but I plan to, I will pay all the back taxes owed to the state and the reinstatement fee, and then the court can order a reinstatement. For this, in this context, if there was something, it's hard to speak in hypotheticals, but if someone filed a reinstatement proceeding with a court, again, that's their right of appeal after they've exhausted their administrative remedies with our office, and the court finds that for whatever reason, after all the facts are laid out there, that either the dissolution was, or the cancellation of the trade name or trademark was improper, or there were more facts than were known at that time, or for whatever reason, and I'm happy to let Mr. Crossman elaborate, but then that directs the court, just like they can with other entity types, to reinstate that registration. I will say that the reason that it exists the way it does in the bill, and I don't have my Title 17 in front of me to track it in to the existing language, but you'll see this only creates a new type of dissolution or cancellation process for trade names and trademarks. There already are. It's just that in most instances, you have to do it through the court system. So that framework isn't already there to judicially reinstate an administrative cancellation.
Thank you, sir. You okay? Follow-up?
Let me try
Keep
again.
going.
So I'm talking specifically about the provision that says the district court may summarily order the secretary to reinstate the canceled registration. I'm wondering, what's the purpose of that sentence in the bill? I understand the concept of the bill, but why are we saying the district court may do that? It seems to me that maybe they can do that if they want to. Does it, or do we have to have this language in there for them to give the judge the option to summarily order reinstatement?
Mr. Rubino, thoughts?
Thank you, Mr. Chairman. Senator Boner, and again, if I'm missing it, I apologize, but that's part of the appeals process, right? If you appeal the cancellation to a court and they do find that it should be reinstated, then that's the summarily reinstatement.
Mr. Chairman, it's okay, thank you.
Mr. Secretary.
Thank you, Mr. Chairman. And I think the other thing, Senator Boner, is I understand, legislatures don't like telling judges what to do, or maybe they do, but judges certainly don't like it. But I think what that sentence, when they drafted it over at LSO, I think what they were trying to do is that there was some concern, to be clear that our actions could be reversed in certain situations. And so I think, and I think it's crafted in a way that, it's a may, and then it says they could take other actions. So, basically, they, as judges evaluate cases and handle it as they see fit, I think that sentence is doing that. It probably could be deleted, but
Wouldn't it be fair to say that using the word summarily, and I'll look to our staff too, that sort of says the court could even do it without holding a hearing. I mean, that gives them, this gives the court maximum flexibility. It doesn't say they have to, they can just issue an order if they're persuaded in the filings to do so. Would that be fair? Senator Boner, we're gonna go back to you.
Yeah, so if I understand, it's kind of giving the court a little bit of a hint, maybe say, hey, feel free to take, move very quickly on this.
Yeah.
And so it may not necessarily, be required, but it's kind of giving them a little hint, maybe say, feel free to hurry up,
It's certainly more flexible than telling the court that they have to go through other standards to reach this conclusion,
right. And Mr.
Back to
Chairman,
you, sir.
thank you for pointing that out. And I do not object to deleting the sentence. I certainly don't object to deleting summarily, but I'll leave that up to you. I don't.
I think we're good.
I think you're right that that's what I think about slib work. I mean, when you have a something summarily rejected, that's when the office doesn't even bring it before the board. So that's
Fair enough.
and so I think that's what they're getting at there.
Yeah. Anybody else on this? Senator Dockstader.
Mr. Chairman, maybe a question for you, Joe, and you probably said this summer. The whole issue is around canceling trademarks, rights to appeal.
Your mic's on. Good. I didn't hear you.
And so we had about 60 some odd cases, 5 or 6 came back and you're able to correct. What brought us to this point that we need this piece of legislation? You probably said it this summer, but I need to know, understand.
Mr. Rubino?
Well, Mr. Chairman, Senator Dockstader, I think that's probably better illustrated by Mr. Crossman, and that was the situation that he was talking about in there. Obviously, it's hard to forecast exactly what may come up in the future, but that was a prime example of something that very well could lead to costly litigation protracted for months, if not years, over something that, if it's brought to our attention, a trade name or trademark could be just canceled with our office and taken care of. So it's just really another tool that could be used to help ease administrative burden for lawfully registered holders of trade names and trademarks.
And if I might interject just 1 second, there's a large amount of protection for Wyoming companies because if someone's obviously like trying to be deceptively similar to them and kind of take over their turf, we're protecting Wyoming companies by saying, we could get this handled right away without having you go to court in this long protracted thing. I mean, I think that might be a gist of it, and I didn't mean to cut you off,
That's
so.
it, you're seeing enough of these cases, that we need to have this.
Mr. Crosman.
Yeah, thank you, Mr. Chairman. Senator Dockstader. In this particular context, I've only seen a handful, but what we do see many of these kinds of things in the entity context. And when we were presented with one, that's when we realized that the powers that we have in this context do not line up with the powers that we have in every other context. So when this person came to us and said, what can I do? And I did the research and I'm sorry, I can't do anything. If they had done this with an LLC or a nonprofit, we could have taken action overnight. But so in some sense, you can see this as attempting to conform the language of those two concepts with the general Title 17.
Thank you, sir. Thank you, Mr. Crossman.
Mr. Chairman,
Senator Steinmetz,
if it's
let's go to
okay.
Mr. Secretary.
Yeah, thank you, Mr. Chairman. And Senator Dockstader, just want to clarify, when I was talking about the 60, I was talking about corporate dissolutions where we already have this authority. And that's kind of why I brought it into this. One, I wanted to say that we're using this now because we take fraud very seriously in the corporate setting. But two, we're just trying to align our trade name and trademark duties with the dissolution authority that we have for the other situations.
Thank you, sir. Senator Steinmetz.
Thank you, Mr. Chairman. Well, first of all, I just have a few remarks. I'd like to thank you for bringing this bill because I have a trademark with your office, and the idea of having to go to court to defend it can be a deterrent to even taking that measure because it's so expensive. And so I think this is really needed, and I want to thank you for bringing it.
Thank you, Senator. So I think we're at the point where we could hear some public testimony, and you guys, is anybody in the room going to testify on this bill? So you can sit right there if you don't mind. Is there anybody online that wishes to testify on this bill? Check that. I don't think we have anybody online. We don't have anybody here. So we'll proceed to the vote, but preliminary little timeout about housekeeping. We have 4 bills. I don't know if we're going to get through them all today, but that would certainly be our intention. And Senator Steinmetz isn't going to be here on Monday when these bills could be the earliest taken up. So I'd like to think about dividing the 4 bills up within the 4 members, including our new friend. So think about which bill you might want to carry. So anyway, with all that, we've heard the testimony. What is your pleasure, committee? Motion by Steinmetz. Discussion. Any proposed amendments or? Yeah, I kind of think this is a great concept, you guys. I think it was good work of the interim. We back and forth. It does, in my mind, really protect Wyoming companies. You know, it's not just Wyoming companies either. You can have a trademark and not be necessarily a Wyoming domiciled company. But on the other hand, it protects the legitimacy of friends and partners we've been working with for a long time, probably. Any comments, discussion? Let's just have the roll call.
This is a roll call for Senate File 0053, Trademarks and Trade Names Administrative Cancellation. Senator Boner.
Aye.
Senator Dockstader.
Aye.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye. So we've got 5 ayes, everybody. Just by way of committee assignments, Senator Dockstader, would you like this one? You could be your first one. You'll be great.
Could you send me your notes?
You guys can talk back and forth. That's great. All right, the next file for our consideration is Senate File 55, third-party filers. Who will take us, Mr. Secretary?
Well, thank you, Mr. Chairman. I think I'm going to start with sort of the bill draft concept, and then I'll go ahead and walk through this one. Mr. Chairman, as we came out of our discussions from the corporations meeting in April 2023 and 24, and again throughout the interim, and just to remind the rest of the committee that was not with us, the intent of this concept was really to ensure that serial third-party filers, that is, third-party filers that file documents with the Secretary of State's office on behalf of another entity, are verified as real people. So, you know, this is really in the CRA setting, the registered agent setting.
What's CRA? I'm sorry, sir.
It's a commercial registered agent.
Perfect.
So that's the acronym, and it is a centerpiece of our business code. This bill draft would require third-party filers who receive compensation from business entities to file documents on their behalf and who file 10 or more documents with our office to register with our office and provide both a notarized sworn application under penalty of perjury attesting that the third-party filer is a natural person, as well as provide additional documentation including the third-party filer's home address, phone number, email address, and driver's license. And so again, to kind of play out what we're trying to do here, we're very concerned that some of these registered agents are filing documents and signing documents with individuals that are not real people, okay? That is the concern. And there was an amendment we discussed, which I believe was added during our meeting in August, which I did speak to my concerns with during our meeting here in Cheyenne in October, that I did want to address briefly. And this is just my personal position. I just don't think we should be exempting attorneys and certified public accountants if they are licensed in Wyoming from the requirements of this bill on page 2, lines 6 through 10. But again, I want to reiterate that I'm very supportive of this bill. And in terms of the appropriation, I guess we'll go ahead and speak to that when we go through the bill. So, running through this, and Mr. Rubino, if you want to interject as we run through, page 1, obviously, we have the constitutionally required enacting clause, and moving into section 1 here, we have sort of a little bit of a partial windup of a definition of a third-party filer. And then that last sentence, moving to page 2 of that subsection, is the one that did get added in the amendment that I'm not a big fan of, which is that we're exempting attorneys and certified public accountants. And certainly, the reason is I think we should just, when we draft this sort of legislation, we should make it uniform. That's my opinion. Now, on page 2, subsection B is where we really get the pitch thrown. And I really like bills where the pitch is thrown early on, and this is one of them. And, this is where it says a third-party filer shall register with the Secretary of State after filing 10 documents with the Secretary of State in 1 calendar year. And I understand this is prescriptive, but in my opinion, if we're going to attack this fraud, this is the sort of thing that we're going to have to contemplate. In subsection C, moving to page 3, is a little bit on what we would ask for as part of the application. So the Romanet 1, the third-party filer's legal name, the home address, phone number, and email address. Romanet 2, Romanet 3, the third-party filer's business address, phone number, and email address, if applicable. And then Romanet 4 is the driver's license. That's how we ascertain that this is a real person. D is the fee on page 3. And then moving to page 4, E is giving this requirement that, look, if they make changes, they got to tell us to prevent sort of back-end shenanigans. Subsection F is the ability to have an administrative penalty in certain situations when they're in violation of the act. And G is just putting confidentiality on these records, which obviously a license is included here, and that was to allay concerns on that. And certainly I think that's an important provision. And then page 5 is the appropriation. Bottom of page 4 is a rulemaking authority, which just so we can fully implement this. And then page 5, section 3 is the appropriation. Now, I do want to speak to the implementation of this bill. During our committee meetings on this bill in the interim, we had discussed its implementation, which will require a new module for third-party filer registrations to be developed into our existing software, which is called WileSuite, including a form for recording required details and payment. Additionally, automated notifications and reporting will need to be created to manage filers approaching or exceeding the 10-document threshold, prohibiting further filings without registration. During the interim in this bill's infancy, I think it was Senator Landon added an appropriation of $100,000 based on our preliminary estimate. I certainly appreciate that appropriation being there. In speaking with our technology division at our office, and I don't like putting buffers on our appropriation estimates. So when we took the first estimate, it was $100,000, and we did a little more research, and we think it's going to be a little bit closer to $150,000, and that's where we think we're at, and that's in our conversations with our tech director, Micah Fafi, and then also Mr. Crossman. So in terms of our estimate of the number of hours it's going to take to build this, that's where we're at. And so, Mr. Crossman, you want to speak to that a little bit? Is there anything you have to add?
Thanks a lot.
Thank you, Mr. Chairman. So as part of this, when people are filing documents with our office, you have the registered agents. They employ staff, and these staff will file documents with us. But in addition to that, there are entities that are not necessarily Wyoming entities that basically they bifurcate the concept. So they have a Wyoming entity that is the registered agent, the commercial registered agent, the CRA. And then they have another entity that does it's basically the customer-facing component that does the filing. So they execute the documents on behalf of the customer, that's all perfectly legitimate, and then file them and then pass the document off to the CRA for the CRA functions. So now we have these individuals who are not necessarily underneath a company that's a Wyoming company. They're not underneath the CRA, so we don't have visibility or control over them, and we don't know if they're real people. We don't know if they are where they are, who they are. Are they signing documents on behalf of people? Are they attesting to things that they can't because they don't exist? Things like that. So this is to align the people who are actually filing the documents with our office on behalf of others. This has no effect on people who are filing it on their own behalf with the CRA rules, and effectively trying to bring those individuals underneath the CRA rules. But because we're talking about natural persons, that's why we need the additional, looking at their IDs and who they are and where they're located. So that's the purpose of it. And then the technical side is, well, now we know who they are. We now have to track what they're filing and make sure that they are, we have a 10 document threshold. Are we at that, over that, under that? Where are we with that person? Do they have to register yet? And also to track the information on those individuals. So that's where the additional technical burden comes in, is to make sure that can all be done.
Thank you, Mr. Grossman. You guys ready for questions? Who's got questions? Let's go with Senator Landon.
Thank you, Mr. Chairman. Appreciate it, Mr. Secretary. During your explanation of the bill, I had a question for the top of page 4. Have you contemplated what that rule is going to look like? I'm just trying to think of how often somebody's going to have to get in contact with you. You would, and if they're not staying in contact with you, how do you handle that part of things? I'm just kind of trying to think of how do we get this locked down, and if somebody's bouncing around and changing addresses, and any thoughts on that? You think there's going to be any struggle on the rule front for this?
Mr. Secretary.
Well, Mr. Chairman, thank you. And Senator Lane, we haven't sketched out a draft, obviously but thinking about it conceptually a little bit, I mean, I think that, I think that we would set out in that rulemaking, as the statute would say, that changes need to be reported to our office, and then create a procedure and when they're not. And, I think we would have some sort of line that says, look, upon notification, somebody can correct it. But, that we don't want to go too far that direction so that people have endless outs. But, maybe we'd give one shot at that, maybe. I mean, I think we debated a little bit, and then there'd be further action beyond that. You have anything you want to add, Mr. Rubino, to that?
Mr. Rubino.
Mr. Chairman, thank you. Senator Landon, it's a good question. It's one we have tossed around, I know conceptually within our office, and we deal with this to some extent. I won't say it's perfectly analogous, but part of the concept of bringing this in is bringing these third-party filers in really under similar or of like similar type to the oversight that we exercise over commercial registered agents. And a lot of that comes out of this. And some of that, the onus is on the commercial registered agent, say when they do an RA address change. I mean, we had one, I believe it was in, mid to late 2023, and it was a very large CRA here in Cheyenne. And they moved from one address to another, and it was a huge, it's a lot of entities, because they have to move each one individually over in our office so that each record accurately reflects on the public record and the ledger that we have on the filing system. It's available freely on our website, all of those RA address changes. And so, the onus is on that person. I will say, just to get at the crux of exactly what we were talking about, all interim, and it goes back to the last bill that we were talking about, which is when you have to file a document with our office, if you file a fraudulent document with our office, that is a felony. And so it is bringing more of that in where you have more oversight and more onus on the third-party filer, whoever that may be, to bring them in that realm. But will I say that that's, perfect? The onus has to be on them to be able to bring that accurately in.
Yeah, appreciate it, gentlemen. Thanks.
Thank you, Senator. Who else? Senator Boner?
Thank you, Mr. Chairman. You had a little bit of discussion about the appropriation. Just wondering how you anticipate this impacting your workload. Is this going to be contracted out? Can you handle it with current staff? Just a little bit of discussion about that.
Mr. Secretary, and I might tag on, do you want us to put 150 in there?
Yes, Mr. Chairman, thank you. That is our request, Mr. Chairman.
Okay.
I think we can handle the workload. We have, our tech division head, which is, 3 people, but in that tech division, but our lead is going to take that on, and he's fine-tuned that estimate since then. When we did the initial 100,000, he did say that this might be on the low end, but we went ahead and submitted it that way, and because we wanted to continue to engage with our vendor, Tecuity. Tecuity is our tech vendor. It's been that way for decades now, and we were actually one of their first clients. Now they're a leader in the business software space for states that are looking to have these sorts of systems. And it's based on an estimate of how many hours it's going to take to build it. But in crafting the system, we have to sort of build the requirement for the vendor. Here's what we want, and we have to do it very carefully in how they build that narrative, that document, so that when they come back and they produce it, it is actually what we want, not something different. That's what we do in-house.
And just to point out, it's a one-year appropriation, it's a one-time, it doesn't become part of the budget. So it's not $50,000 more a year, it'd be $50,000 one time. Go ahead, Senator Boner.
There are fees associated with it too, so.
Yes.
So there could be, so you are anticipating some ongoing costs, or you just want the option?
With respect to the fees they get from the registered agents?
And Mr. Chairman, I think 2 questions to break down there.
Okay.
One, the fees that we get from registered agents, from individuals now that file with our office, those all go into the general fund. Yeah, so there's no special revenue accounts. Our office we generate a lot of revenue for the state, but that all goes into the general fund. For the second part of your question, I think you were asking about ongoing maintenance, and no, we anticipate this being the one-time cost to build this out and integrate it into our existing software system, which is quite complex, as you can imagine, with all of the different enterprise software filing types for each of these filings, to plug it into that system so that we can, A, allow this type of filing, but B, as Mr. Crossman was saying, and we have a similar sort of infrastructure with commercial registered agents. If you represent 10 or more and you're a registered agent, then you have to register with our office as a commercial registered agent. So many people, if you have a small business, an LLC, a nonprofit, or a for-profit corporation, a lot of people, they serve as their own registered agent. They don't have to register as a CRA because they don't represent more than 10. But once you hit that threshold, then you have to register with our office. It's more oversight.
Thank you.
And Mr. Chairman, if I may, thank you, Mr. Chairman. We do have 2 new members on the committee. I do want to emphasize, with your indulgence, that we are one of the few revenue centers the state has. I mean, when you think about it, Game and Fish, Department of Revenue, although I'm not sure I really count them, maybe Treasurer's Office, although that's off investments.
Department of Insurance.
That's a good one.
Yeah.
That's good. I should add that to the list. Thank you.
Yeah.
And we're one of them. And so, it is something, I mean, this pays for itself in about 1 business day, I think it would, in terms of our business filings.
You bet.
Yeah.
Let's see if anybody down here? Senator Steinmetz.
Thank you, Mr. Chairman. Being new to the committee, I just wondered about the 10 threshold. Is there some reason you have the number 10? Is that a magic number? You mentioned it is in another section of how you classify registrants, so that's on page 2, that it's if they file 10 documents, why isn't it 5? Or that was one question. And then I think Senator Boner covered the rest of what I was thinking, because we all know that our subscription fees are one of our biggest expenses, going up and up and up. But I do know that your office does generate a lot of income for the state. And so even if it was a marginal fee, it would be worth the investment in your office, so.
And thank you, Senator. I might comment on the number 10. I was around when we actually put that in. It's finding a balance between, where people they might do this for a living, be a registered agent. I mean, they'd have other lines of work, but it's not uncommon for, even a family to have several companies, associated companies, or it's just sort of seemed like 10 is where you go into the big level where it's professional. We could change that, but it was a fight long ago. I think it actually came under Max Maxfield, if I remember right, when we actually we developed commercial registered agents for the first time in an attempt to try to regulate this field a little bit more. And I think that's where 10 came from, if I might recall, but please, you guys, if you want to help.
Yeah, Mr. Chairman, I might turn this over to Mr. Crossman, because Mr. Crossman, I believe, when he originally, in our office, something we brought to the fraud working group, but Mr. Crossman really is the provenance in terms of our offices thinking on this, one of the provenances. So I think you did think about this a little bit, so.
Mr. Crossman.
Thank you, Mr. Chairman. So the 10 does refer back to the commercial registered agents. If you were to be a registered agent, not a commercial registered agent, you can represent up to 10 entities without registering as a commercial registered agent, which does require heightened paperwork with our office and some fees. And at that point, then you're considered a professional. So we took that 10 figure from that piece, which, as the chairman mentioned, that came from the original creation of the commercial registered agent. We could go to take this to 100 or 50 or 5, but we feel that the 10 lines up with the existing statute well. Going back to the registered agent concept, the reason why we put that at 10, or I believe the reason why that's put at 10, is because it's relatively easy for an individual or a family to have multiple entities, multiple LLCs. In the context of, for instance, rental housing, they may put each property inside of a single LLC. And if you have 12 properties, now all of a sudden you have to register as a commercial registered agent. That's fine, but at that point, you're a fairly large operation. Whereas if you just have 1 or 2, we don't feel the need to have you go through the process of registering, because that's just a couple of LLCs and they're all yours.
And Mr. Crossman, it includes all different types of entities,
Yes,
right?
yes.
So I'm kind of thinking my personal circumstance. I'm on the board of a few nonprofits. I'm actually the treasurer and the registered agent for several of them. And this is a good time to say, I appreciate your reminders that you give. You guys are the best on that when reports are due. But so I have an entity called the Chief Washkey Foundation. I'm the registered agent for that. The Dickinson Creek Irrigation Company. We have an irrigation company, registered agent for that. I have 2 businesses that have merged. One owns the other, but they both have filings. So that's 4 right there, and I think I'm missing something. But so it's not hard, especially in terms of being a volunteer, just out there and taking on being the secretary for volunteer entities or different things. It piles right up. It's just an idea. Mr. Rubino? I thought you okay. Anybody else? Is there any public testimony on this? And before we do that, I do want to say some of the, I want to do a shout out to our assessors, because Tara Berg, the assessor from Fremont County, helped us to find, she was very diligent and met with us in the interim, talking about, she monitors the filings at your office and then tries to find when there's an address listed in Fremont County, she would send notice to that address to see if they had any business personal property that should be taxable or and lo and behold, that's where this thing just exploded in a way that there were people, ordinary people that were listed, their addresses were listed as being part of these companies, or even being the registered agent for these companies. And it's just not true. It was just totally, and it causes great angst when people get letters in the mail and, you've lived in your house for 30 years and you're being told that you're the registered agent for XYZ company, and you may not find out about it until the assessor sends you a letter and you're going, what is this about? And so she was very helpful, and I think that's kind of happening around the state. And I noticed we've got an assessor here from the mother county, Dixie Huxtable's here, and but I don't know if you would like to comment on it. That's just some preface before we open up for public testimony, and I'm going to center Landon.
Well, Mr. Chairman, I just wanted to thank you for bringing that up, because that was remarkable testimony. And I think the secretaries there throughout, all of you gentlemen were, it was really eye-opening what we had going on out across. Remember, we had a couple of addresses in Shoshone, for example.
One of them was my address.
One of them was the chairman's address, and I'm just thinking, wow, yeah. So nice work, gentlemen, to get honed in on this. And I think, it was just pretty amazing testimony, really.
Was. So is there public testimony in the room? Ms. Huxtable, got to make room for her. I don't know if she needs 3 chairs, but she's. Welcome, Ms. Huxtable.
Thank you, Mr. Chairman, members of the committee, Dixie Huxtable, Converse County Assessor. And I am kind of going to speak on behalf of my colleague from Fremont County. She did an outstanding job for us and actually opened a lot of our eyes. She had dedicated some staff to looking into this. And as we went home after some of those meetings, we all got our eyes opened to looking at the data coming from the Secretary of State's office. So we certainly appreciate this legislation. All 3 bills that you're going to follow up, this one and the following 2, we do appreciate the efforts that are going out there that gives us the opportunity. I think in the last bill you're going to talk about today, hopefully, is the ability for us to request some information so we can follow up. And truthfully, we're just trying to protect our constituents. When you get an 89-year-old lady that's very confused as to why her house is being used for a business that she knows nothing about, yes, they can file the affidavit with the Secretary of State to get it cleaned up, but we're just trying to look out for those folks and make sure that there's something not coming down the pike that's going to hurt them even worse. So we appreciate everything that's out there, and we do support these bills. Thank you.
Thank you. Is there questions for Assessor Huxtable? Thanks a lot for meeting with us today. Anybody else in the room want to testify? Is there anybody online? Okay, committee, we've heard the testimony and the discussion. Is there a motion on the bill? Motion by Boner. Discussion. I'm really excited we're doing this bill. There were a couple of potential amendments that I will note were pointed out in the testimony. Secretary of State's office probably would prefer that we remove the exception for attorneys and certified public accountants who might be registered agents for companies. And then there was the second one about the appropriation. Would either of you, anybody like to pursue that or something else?
Mr. Chairman,
Senator Steinmetz.
I'd like to remove the exception found on page 2, line 6 through 10 after entity.
Okay. Discussion.
Mr. Chairman, I
Go ahead.
just think that it applies equally across the board, no matter who the person is. We should regulate it equally.
I appreciate that, Senator. I think the argument that was in the committee, and I think it was I think Senator Scott brought this originally. And we did have members of the bar there, and they argue that their rules of practice cover what this bill's trying to get, and they are licensed in Wyoming, so it's a little different kettle of fish, if you will, but we will hear from them. There was an attorney here earlier and she left, so I don't know. And I don't know if anybody's following us online, but we would entertain anything online about the amendment if there was. Go ahead, Senator.
Thank you, Mr. Chairman. I just always like a belt and suspenders.
Senator Landon?
Well, Mr. Chairman, thank you. And I appreciate where the Secretary's coming from. It's kind of a little bit of a coin flip for me. I was kind of persuaded during the interim to include the language simply because those CPAs and those attorneys are ours, and they have pretty diligent licensing and oversight. But, you know, I don't want anything, you know, to hurt this bill in any way, because I think it's a really good effort, and so I could basically go either way on it.
Okay. Anything else on it? Should we just put it up? All those in favor of Senator Steinmetz' motion to remove the references to third-party filer being an attorney or member of the bar or a certified public accountant, lines 6 through 10 on page 2, signify by saying aye.
Aye.
I think I've got all sorts of ayes. I'll enter a no on that, and so, but that amendment has passed. And then Senator Dockstader.
Second amendment,
Go ahead, sir.
page 5, lines 1 and 2. Appropriation from 100 to 100
Okay.
from the general fund. Move it on to the re-referral later.
The motion by Dockstader is to increase the appropriation to $150,000, and seems thoroughly appropriate to me. And this bill's going to have to go to appropriations no matter what, so by doing that, we're not changing the timing or anything, and so that's certainly in order. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That's carried. Is there anything else on the bill? Anything else on the bill? I think we're ready to call the roll for as amended.
This is a roll call vote for Senate File SF0055, third-party filers. Senator Boner.
Aye.
Senator Dockstader. Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye.
5 ayes.
Great. And who would like to carry this one on the floor? Senator Boner, you got it. I think you can expect an effort it'll be a standing committee amendment with the two parts. You probably can expect an effort to divide the standing committee amendment. I think as a courtesy, we should let Senator Scott know about it so he can prepare his best arguments, and we'll just kind of expect that. Okay. The next file for our consideration is Senate File 56, providing false information to registered agents. Welcome back up, you guys. Mr. Secretary.
Thank you, Mr. Chairman. Well, Senate File 56, providing false information to registered agents, is another bill that came out of the fraud working group and that our office is fully in support of and recommended. This would add another tool to our toolkit in both identifying and taking action to administratively dissolve business entities if we are notified that the business entity has provided false or fraudulent information to its registered agent. From a high level, I think this bill is not only necessary, but in our conversations with some commercial registered agents throughout the interim, including Mr. Scott Meyer, who participated in the business fraud working group, I think it's something that would be highly beneficial to the registered agent community and to our state. As a little background, business entities that employ a registered agent are required to provide their registered agent certain contact information, which may be audited by our office. Under our administration, our office has increased these audits of commercial registered agents, checking for compliance by the commercial registered agent in keeping this information. However, our office does not have power to take any action against the underlying entity if the underlying entity is providing false or fraudulent information to the registered agent to begin with. Essentially, the trigger for administrative dissolution in this bill would occur in two instances. One, during an audit of a commercial registered agent, if we determine that an entity has filed false or fraudulent information to their registered agent, or two, if we are notified by the registered agent that a business entity has filed false or fraudulent information with the registered agent. This bill does not have any direct fiscal impact on our office because it essentially fits into our existing dissolution process, but would be utilized by our business division to ensure the integrity of documents filed with our office and that may be audited by our office. Now, to walk through the bill, I'm going to go ahead and turn it over to Mr. Rubino because the dissolution authority is tracked in here in 5 or 6 different places. It's similar alignment, but just to track it into the title, into the code, into 17, I thought it'd be helpful to have Mr. Rubino walk through that.
Thank you, Mr. Secretary. Mr. Rubino.
Thank you, Mr. Chairman. Yeah, beginning on the bottom of page 1, going on to page 2, dealing with 17, 16, 14, 20. This deals with the, let's see, profit corporations, Wyoming Corporation Act, and it's really providing the new language there at the bottom of page 2, line beginning on 22, capital D. This is really the meat of it all. Has provided false or fraudulent information to not just our office, but to the registered agent as determined by the Secretary of State during or following an examination of records, what we call a CRA audit, or following notification by that registered agent. 17, 16, 15, 30 deals with revocation of a certificate of authority for a foreign corporation. And going on to page 3, on page 4, lines 1 through 5, that's the new language, adding a new grounds for revoking that certificate of authority for a foreign corporation who does the same thing. 17, 19, 14, 20. Just want to make sure that I'm not speaking to.
And as Mr. Rubino's finding that, I just,
Sure, Mr. Secretary.
we have 6 references, and I'm sure you see this, but it's the same construction tracked into the dissolution authority 6 times so that we're complete in that authority, so.
Right, and to tag on with you, sir, it deals with different types of entities that are doing business in Wyoming, and it's just making the same language in each area, which are separate laws, but
Right.
keep going. It'd be nice to know which each one of them is.
Right. 1420 deals with nonprofit corporations.
Okay,
17, 19, 15, 30, they're on page 5, going on to page 6. This deals with the revocation of authority for foreign nonprofit corporations.
and Mr. Rubino, 101, foreign in this context means
Yeah.
not domesticated in Wyoming. right?
Great question, Mr. Chairman, and one that we wrestled with throughout the not wrestled with, but there were repeated questions on that coming up, because I know that when we talk about foreign versus domestic, really in a layman's context, we're talking about outside the United States. Under Title 17, the business entity statutes, foreign is any entity that is formed outside the state of Wyoming. For a lot of them, that's Delaware. Delaware is number 1, and Wyoming is number 2. And so we see a lot of Delaware corporations, nonprofit, profit corporations that receive certificates of authority to do business in the state of Wyoming. So that's, I'm
Great.
glad you asked that.
Keep going.
705 is also.
It's 705.
705, there on page 6, going on to page 7 is limited liability companies. And then 1730-904, 7 and 8, that's the certificate of authority, I believe, for foreign limited liability companies.
foreign LLCs.
Yeah.
And then we just have an effective date. July 1,
Yes, Mr. Chairman, we're effective July 1, 2025, rather than immediately.
and no appropriation?
No.
And, great. Committee, any questions on this one? Any questions? Good, I guess we can go to public testimony. Anybody in the audience wish to testify? You guys can stay right there. Anybody online? Okay. Committee, you've heard the testimony. What is your pleasure?
Move the bill.
Motion by Landon. Any discussion? I'm excited about this bill, actually. I mean, it really, it closes a loophole where we have, the registered agent can hide behind the fact that they're doing their job. They don't ascertain all this stuff, but they can have assurance now that the person is committing a fraud if they gives them false information that they use in these filings. And it kind of fits with what we're trying to get after here. So, any other discussion? Any proposed amendments? Let's call the roll on this one.
This is a roll call for Senate File SF0056, providing false information to registered agents. Senator Boner.
Aye.
Senator Dockstader. Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye.
5 ayes.
Okay, and we'll put Senator Landon's name on that one. I imagine you might get a lot of questions about the types of business entities and the foreign, but that'll be good. I know your office will help him.
So, Mr. Rubino, can you come out on the floor with me and then that?
Well, that won't be possible, but it'll be really straightforward. And you remember, we have two people on the bench. Senator Scott will be on the bench, and former Chairman Olson, House Chairman of this committee, is now a member of our body, and he'll be on the bench on this one. You might be on the bench, the other side's bench on the lawyers and
Yeah, that's right.
he might be over there. But now, the next file for our consideration is Senate File 59, Registered Agents Release of Records. This is another product of our interim work and fraud working group. And Mr. Secretary, to you.
Yes, thank you, Mr. Chairman. Now we proceed to Senate File 59, Registered Agents Release of Records. Again, I appreciate the committee's time in allowing us to speak on this bill and its implications. This is a little bit unlike the other three we discussed today. This was one that did not originate from our office. It is probably the bill, no, it isn't probably. It is the bill of all the ones that came out of the working group that I am least excited about. I have not voiced opposition on it, and I will not today, but it is the one I'm least excited about. I do have some concerns on the implications on it. Certainly agree that we should be addressing fraud and understand the thrust of it. I do want to thank the committee. During the July corporations meeting in Evanston and again in October, our office voiced several concerns about how the original bill draft was written and about our concern with allowing all governments, including even special districts, the way it was written, to be able to request this information, and then also not to use our office as a clearinghouse for it. Now, that's really inconsistent with the code and the need for collaboration in the dissolution process, and the fact that that's already contemplated in the code with law enforcement even having to come through us for this information. So those amendments did clean that up, and we appreciate the committee's listening to our concerns of the original bill draft, which is written, raised several due process concerns. These amendments did provide some major sideboards ensuring confidentiality and providing that as the registrar of business records, our office would act as the clearinghouse for this information, just as we do even with law enforcement that has a subpoena, and that these records would need to remain confidential and could only be used for an official governmental purpose. While I still have some policy concerns with placing county officials that are not law enforcement on the same par as a bona fide law enforcement agency for use in a criminal investigation without needing a subpoena for these records. I mean, right now they need a subpoena for these records, law enforcement, but the assessors or treasurers would not. I do appreciate the improvements. I'm certainly interested to hear from the CRA community on this bill, and that's our main comments in presenting the bill here. It's pretty simple. The new language on page 2, which is tracked into the production of records, which is of course in Title 17. And it states here, the Secretary of State may release, and again, this is new language, this is current language, but it'll feed into new language, but the Secretary of State may release any such confidential information only pursuant to court-ordered subpoena to a bona fide law enforcement agency for use in a criminal investigation, and now we get to the new language, or upon written application to a county assessor or county treasurer to obtain the information for official business. Any records obtained by a county assessor or county treasurer pursuant to the subsection shall be held confidential, provided that the county assessor or county treasurer may release such confidential information only pursuant to a court-ordered subpoena or to a bona fide law enforcement agency for use in a criminal investigation. So I think that language kind of speaks for itself, but certainly any questions? Thank you.
Thank you, Ms. Secretary. Appreciate it. Appreciate your help with this, and I know it's not your favorite bill. By way of background, we kind of came through originally with a bill that just allowed county officials and others to directly request the information from a registered agent, and that the registered agent would have to provide it. This is where the bill evolved to. This actually was a completely different draft. And so I think kind of this is where we ended up. I think we'll hear from our assessors on this bill today and kind of why they support it and what it's trying to do. But questions for the Secretary from the committee? Any questions? Let's hear from the assessor's office. Thank you. And again, just before, while Ms. Huxtable's coming up, remember when Tara Berg spoke to the committee and said that she had been reaching out to some of these registered agents that indicated that there was a business address in Fremont County and was told that they didn't have to provide her with any information about who owned the business, kind of where she could send a tax notice, like all that kind of thing. So Ms. Huxtable, you'll do a much better job than I ever could, so please welcome.
Thank you, Mr. Chairman, members of the committee. Dixie Huxtable, Converse County Assessor. And again, I'm supporting my colleague here who unfortunately had to go home because of the storm and be home. So she left a day early to get home. So we do appreciate this bill. Just to ease any concerns about the confidentiality, we do have confidentiality requirements already in our offices. Personal property declarations, certain income documents, certain sales confidential. When you sign a statement of consideration for the sale of a property, that's confidential. So we're very used to handling confidential information and storing it in such a way and making sure it stays confidential. So I have no concerns about that. But you're exactly right, Mr. Chairman. This came about because of us doing our due diligence to try to make sure we have all the taxable property on a tax roll. We get new businesses all the time in our counties that don't know or understand or just don't wish to report their businesses to us. And so we use a variety of methods to try to find those when we get a new one, social media, newspapers, and of course, the Secretary of State's new filings is an excellent place. But when we reach out to those and we find out that those constituents, as I mentioned before, know nothing about what we're talking about, and then you're trying to find out who's the person involved, who do we need to reach out to, and you get the door slammed or locked on you and you can't talk to them anymore. This is an avenue that with a proper written request, we can ask for that information from the Secretary of State. And I would say that it says may. It doesn't say they have to give it to us. It says they may. So if we don't document our needs properly, I would certainly expect the Secretary of State's office to ask for that. So it's not just an automatic, we ask for it and we're going to get it. We're going to have to do our due diligence as well. And we fully expect to do that. And we do appreciate this bill. The revisions are conforming to what we need. And we do support any concerns that you have. We can certainly try to address those, but we do support this bill. And I would stand for any questions.
And Ms. Huxtable, could you give an example? Maybe it could be hypothetical, but maybe a situation where we all have a constituent, a person that lives in our community, that's house or business address is also on the filing for some other entity that they don't know anything about, and there's a paper trail that might take you to a registered agent somewhere, but you contact that registered agent to try to clear up this situation, and they tell you they don't have to give you the information. I mean, is that accurate, or kind of
Mr.
colors of
Chairman,
that to you?
Mr. Chairman, that is exactly accurate. I mean, that is a generic situation without using names that happens a couple of times in my county, because I have not, I'll be honest, I've not done the due diligence that the Fremont County has. I'm just getting started at that, and I've not had as much difficulty as she have. But I do know that there are some other counties that have had that, where they send the letter, or when the staff is going through the Secretary of State's filings, and you send out the letter, and you recognize an address that seems to be somebody that is not appropriate, and I think you can recognize that comment yourself, Chairman, and you send the letter, or you reach out to that taxpayer and ask, what, you have a new business, this says your business XYZ Corporation is at your address. They know nothing about it, they've not talked to anybody, they've had no phone call. So then you follow up to try to find the registered agent who filed that company to see what more information you can get. Maybe there was an error, maybe there was something. And that registered agent is getting very emphatic. We do not need to talk to you. We don't have to give you any information. This is all confidential in the state of Wyoming. You're kind of on your own. And the only recourse that we understand is that that taxpayer that knows nothing about this
Who
can
might
file
be
an.
90 years old.
The last one that Ms. Berg responded to me was an 89-year-old lady that we happen to know through acquaintances, and have that person file the affidavit with the Secretary of State's to start the process of getting that removed. If we can step in and help by asking this information and verifying and giving them some tools and some advance notice, we feel that's kind of our duty to our constituents. We have a responsibility to them as well. And so we kind of started the ball rolling because we sent them the letter about their business that they never, ever had.
Thank you, Ms. Huxtable. Questions for Ms. Huxtable? Senator Steinmetz.
Thank you, Mr. Chairman. Hi, Dixie.
Hi.
So I was just wondering, I'm new to this committee, so help me out. It seems like this is duplicative with what we're doing in the Secretary of State's office, giving them the ability to investigate these things and take action. And so can you help me iron that out about how all of this works together and if it's all needed?
Ms. Huxtable.
Mr. Chairman, certainly, Senator Steinmetz. The Secretary of State obviously has the authority to do that, and that's what you're trying to establish with these bills, the fraudulent, if they know about it. That taxpayer that we've sent that letter to did not know their address was included. They did not know that that was listed as a business address because nobody had reached out to them. I'm not sure that the Secretary of State's office would have ever known that that one was a fraudulent or that there was a problem with that filing. So we feel like, because this is part of our job to find all the taxable property in our county, and that's one of the steps we're doing. If we have the ability to confirm that, yes, it is a business that should have taxable property in our county, or that it's not, if we can do that by going through the Secretary of State's office in that first step to alleviate the concerns for the taxpayer, then we have grounds to move forward. And we can't file, as I understand it, now I'm going to defer to this, and the Secretary of State's office can certainly pick this up. If we find a fraudulent problem and we go to the Secretary of State's, they can investigate, but it takes the affidavit, as we understand it, a document from that taxpayer that has the fraudulent information on the documents to file to the Secretary of State to get it removed. Now, maybe some of these bills will change that. I truly will defer to them to say that. But right now, we feel like this is the best way for us to help our constituents get that taken care of immediately and let the Secretary of State's office know there's a problem.
And I think there's also the tax issue. I mean, they have a sworn obligation to try to collect all taxes due to the state of Wyoming or due to their local entities. So there's that aspect as well. This helps in their mission. Back to you, Senator Steinmetz.
Thank you, Mr. Chairman. And that's, I was just trying to figure out jurisdictionally if it makes sense to put all of that tracking on you, or your office could utilize the Secretary of State to do that work, since we're putting, the onus kind of on them, and come back and do that work for you and then report to you what their investigation has yielded.
Ms.
And
Huxtable.
taking the burden a little bit off excuse me, Mr. Chairman, off your office, because I know you guys have a lot of work to do, but thank you, Mr. Chairman.
Ms.
Mr.
Ms. Huxtable,
Chairman,
and before she
Senator
does that, it goes both ways. They have a sphere of responsibility involving the collection of taxes. The Secretary of State's office obviously has a sphere of responsibility with regards to legality of business entities, their ability to do business in Wyoming, preventing fraud, but there is an overlap. And the question is, in the area of getting the right people to collect the taxes. And the other part of it is, the Secretary of State's office doesn't have local people. They don't have people in Lander that know that, my God, that can't possibly be Mrs. Jones. There's no way that she has 5 companies running out of her house. And she's in the nursing home right now, by the way. So I think that it's actually helping to have more people looking for the same thing in terms of the big area of fraud. But I didn't mean to hijack your question, but I did. And Ms. Huxtable, you should go right ahead.
Mr. Chairman, thank you for that response, because that's exactly where I was going to go with this, Senator Steinmetz. We are on the ground, we are feet on the ground, and we know our constituents probably better than the Secretary of State does, just because we're local. And that is our job, to find all taxable property in our county and to see that it's all taxed. And so we are trying to use every avenue that we can legally and use the best information we have. And we just feel this is one more step to get our job done and to protect our constituents and to help inform the Secretary of State when there is a problem that they may not have even known about it without our initial reach out. And so we're just trying to help in this process and really look out for our constituents at the same time. I hope that answered your question.
Anybody else, Senator Landon?
Mr. Chairman, thank you, and Ms. Huxtable, thanks for being here. It's been really helpful. I went away from the interim liking this bill for the fact that it just felt like a fairness issue to me, too. Not just a protection for our consumers and constituents, but we have a lot of entities playing by the rules and paying the taxes and doing what they do in their communities. And if this helps you to identify somebody who's not playing by those rules, I'm all for it. So is that a misconstrued notion that I took away, this fairness thing, or?
Ms. Huxtable?
Mr. Chairman, Senator Landon, no, I believe we do feel that this puts us, helps us put all the taxpayers on the same playing field as far as for taxation purposes and playing by the same game. And there's a lot of these that are filed that don't have taxable property in Wyoming, but we don't know that until we reach out. We don't know that they're just paper pushing, not actually doing anything else. And so until we reach out, that is not a known fact.
Thank you. Anybody else?
Well,
Senator Dockstader?
they're reaching out, are your offices across the state, how do they deal with that extra work?
Who are you directing that question to?
To Ms. Huxtable,
Um,
the assessor's agenda.
Mr. Chairman,
Go
Senator
ahead.
Dockstader, it is a workload. It's part of our duties. In most offices, we do have somebody that is the clerk or the overseer of the personal property, and that's kind of their job, is to track businesses that come into the community. And so it's part of our normal duties. It's just that in some counties where they've gotten these extra third-party agents, it's a bigger workload. Thousands of recordings, where in my county, when I looked at mine for a quarter, there was some names I didn't recognize, but there was some that I did recognize, and it was a manageable number for my staff to deal with. But in some of these counties where these registered agents or third-party filers have picked up an address and that's where they're doing their business, it is a workload. And I do know that the Fremont County Assessor had somebody dedicated to that. So they do it in the normal business. This just amplified it. And then when the problems occurred, of course, that made the job even more concerning that we get it right, that we make sure we're doing it right.
Yeah, and Ms. Huxtable, thank you for that. And Senator Dockstader and committee, I'm not really sure. I think a lot of counties haven't really tackled this yet, so they don't even know. And unless, one way they might know is they might be contacted by taxpayers who are getting these, somehow they're related, but unless the assessor sends out a letter to the taxpayer saying, this is the location for XYZ company, that's hypothetical, fill out the tax form, taxpayers may not know that they are, at least not know yet, that their address is being listed for a company. And we're still working through that. And so, but I got to commend Assessor Berg. I mean, she really went after that. And I think there's kind of a tradition among the other assessors to go after any new business that seems to be in the county to make sure they're aware of their tax obligations.
Mr.
And she just fell right into it. I mean, there were people that we know, there were even existing businesses that they were being listed for this new entity that they knew nothing about. One of the fraudulent acts was on some vacant lot that my company owns behind the hotel in Lander. I mean, literally, then I'm going, really? It's, at least in Fremont County, it seems to be quite extensive. And I don't think it has a nexus within Fremont County. I think it's an outside nexus somehow. And I'm just wondering what we don't know across the state. Ms. Huxtable.
Mr. Chairman, I will say that when Assessor Berg brought this to the association, it was eye-opening to a lot of our members, including myself. I knew of the process of doing it, but I hadn't actually delved into it. So we did do that on behalf of the association countywide. And at one point, and I can't quote the date, but we looked at all the counties and tried to look at which counties seem to be the targeted or which counties seem to need some more help. And we have reached out as an association to help each other to try to identify when you have an anomaly of number of them or different names or something that you can identify that might be not the normal. So we are working on it. We're not there. It is a work in progress, as you said. But we are helping each other across the association to identify these. And certainly some counties have no problem with it. And some counties are being targeted, in my opinion, because they just get overloaded. So we are working on it. It's just a work in progress. We have a few other things on the table right now in our office in regards to property taxes. So it is a work in progress, but we aren't there yet.
Yeah. So, anything else? Thank you, Ms. Huxtable. Any other testimony from this room? Is there any testimony online? Did you want to respond, Ms. Secretary? You bet. And then we'll go to online next. Thank you, Ms. Secretary.
So a little more background. I know we talked about this in the interim committee, but after the April meeting in Lander, I sent a letter to the county assessors and the county treasurers telling them this process we have for dissolution and the need for them to report these instances to our office. And I want to make sure that we maintain that collaboration because, I understand that, at least on the assessor side, they feel that this is important for data for tax purposes, but.
Well, and they're elected,
Right, but from our side, I'm really concerned also on the dissolution authority. And so it's going to be important that they maintain that collaboration because without that, we can't get to the bottom of it. So, thank you.
You're absolutely right, sir. And we'll help you, I think, to make sure that we continue to have this good collaboration. Thank you for that. Thank you very much. Ms. Sharp, is there anything online? Okay, I think we've had all the testimony. What's your pleasure? I heard Dockstader first. So any discussion? Any discussion? I do hope we'll move this bill forward. If we've disturbed the balance in a significant way, we can address it. But I tell our two new members, if you would have heard the testimony in Lander, it was quite poignant. And you just felt terrible for these people. And, yeah, their addresses have been used and sure, they can help to do the affidavits and help to pursue the dissolution of this entity. And I hope they'll do that. Maybe the assessors and treasurers can actually help them to do that a little bit. Maybe a partnership could happen in there. And, I'm very positive about this bill. And, you know, it will empower public servants that are duly elected that represent the entirety of their counties. So, any further discussion, anything? Could you call the roll on this one?
This is a roll call for Senate File SF0059, Registered Agents Release of Records. Senator Boner.
Aye.
Senator Dockstader.
Aye.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye.
5 ayes.
Thank you, guys. Have a great day. I think you're in the clear for a while. We'll catch up with you a little later in the deal. Thanks a lot. Committee, we're going to